are watching another episode of the Method to the Music show. And just like there's a method to the madness in life, there is a method to the music business. I am your host, Tynia Coats, Ty Law, and yeah, I am an entertainment attorney in the music business, and I am also currently a professor at the Roc Nation School of Music, Sports, and Entertainment, where I am teaching legal aspects of the music industry. In today's episode, we are going to talk about music copyright law, specifically copyright termination, and how you can take your rights back from a record label or publishing company. That's also going to touch on other important need to know concepts as well. So we'll get into that as well. And I know I have not updated you guys about why I disappeared. Again, as always, but I'll put that at the end of this video. For now, let's just get into the information. Okay, so yesterday, Dame Dash posted a video about the Jay-Z Rocafella Reasonable Doubt auction. And if you don't know about this, then just Google it. You can find all the information. But in a nutshell, the city of New York is auctioning off Dame Dash's share of Rocafella Records to pay for some lawsuits that he lost. And the biggest asset of Rocafella Records is the master rights to Jay-Z's album, Reasonable Doubt. Now, Jay-Z, he has put it out there to the public that whoever buys these rights, they will not be getting much value out of it because he gets to terminate these rights in 6 years and they're just going to come back to him anyways. But yesterday, Dame Dash posted a video saying that the state of New York says that the rights to Reasonable Doubt will not revert back to Jay-Z in 6 years because he does not actually have copyright termination rights. And this is what brings us to today's video. And I actually just taught about copyright termination to my class at the Roc Nation School during our first ever class. Shout out to them. So I was like, ooh, that's a good topic to do a video on since I already prepared a lesson plan kind of about copyright termination. So what exactly is copyright termination? Under the Copyright Act, there is a copyright law that allows the authors of a copyrighted song to take back the rights to the song 35 to 40 years after they granted the ownership rights to a record label or a publishing company. If you see me looking at this clicker, it's because I'm just looking at my slides that I already had from class since they're already here. It saves me the effort, but yes. So the government, they created this law as a protection for music creators who get themselves into shitty deals and sign away their rights, not really knowing what they're doing. There's a different law that applies to songs that are created before January 1st, 1978. But for this video, just know that I am only talking about the copyright law for songs that are created after January 1st, 1978. So for all the songs created after 1978, if you are an author of that song, then the copyright law allows you to terminate any grants of ownership that you gave to someone else 35 to 40 years after you signed over those rights to them, and you can take back ownership and recapture those rights for yourself. Yes, I know it sounds too good to be true, but it is true. So let me just give you an example. It's 2024. If you sign a record deal or a publishing deal this year, then 35 years from now, in 2059, you would be able to get your rights back from that record label or from that publisher for whatever songs you signed over this year, 2024. And this is a matter of law, which means that even if the contract says that they have those rights to that song in perpetuity, you can still take back your rights. Even if you never recouped the advance that they gave you, you can still use the copyright termination law to take back your rights. This is a right that trumps all of that. Now, to do this, you have to give advance notice to whoever currently owns the copyright at that time, 35 years later. And this notice must be filed with the Copyright Office. This is something that you would use a lawyer for, so don't try to do it on your own. And if you do need a lawyer to do this, then look no further because you should just hire me. No, but seriously, if you are looking for someone to help you with copyright termination, please do reach out. Anyway, not only do you have to give them notice, this notice has to be given at least 10 years before the copyright termination date or no later than 2 years before the copyright termination date. So that just means that you have to give notice within 25 years to 38 years after you sign those rights away. So going back to my 2024 example, the copyright termination date would be in 2059. So for notice, you would have to give notice to the record label or the publisher anytime between the years 2049 and 2062. Now, if you do not do it in this time period, then you lose the right to take your copyrights back. Keep that in mind. It has to be during that time. After that, you do not have that right anymore, guys. Now, before giving notice, you must also be an author of the song. And I keep trying to stress that you need to be an author to take these rights back. And that's not as straightforward as you would think. Most songs are created by multiple people. So the song's authorship could be considered a joint work, which means that a majority of the authors would need to give notice to be able to take these rights back. That's one of the ways that it's not so straightforward. Also, some songs are created as works for hire, and the copyright termination law does not apply to works made for hire. And I have to point this out, like absolutely have to point this out because it makes an important difference. So as a reminder to everyone who already watches my videos and to teach those of you who do not watch my videos, there are 2 separate copyrights in every song. And I try to drill this in everyone's head as much as possible. So there's a copyright in the musical work, the composition, which covers the lyrics, the melody, and the music as it is written. And then there's a copyright in the sound recording, which covers the actual audio recording of the song. And the sound recording copyright is what people refer to in this industry as the master. And that's typically owned by a record label or the artists and or the artists whose voice is on the audio recording. The composition copyright is typically referred to as the publishing, and it's normally owned by songwriters, producers, and publishers. And if you don't have a publisher, then you are considered to be self-published. Now, with copyright termination, you are normally always able to do this on the composition side, on the publishing side, all the time. You're not really going to run into any issues when you're trying to take your rights back 35 years later. As long as you're the author of the lyrics, the melody, or the beat, you should be able to do this. However, on the master sound recording side, it is trickier and there are more issues because the sound recording copyright has more limitations on it under the law than the composition copyright. Also, in every record deal contract, there will be language in there that says that you are granting them the rights to your master sound recordings as a work made for hire. And remember, I just said that copyright termination law does not apply to works made for hire. So that is why record labels do that. That's why they stick it in those contracts. So they can try to skirt around you. So they can try to skirt around having to give you your rights back. It's shitty, but you know, that's a whole nother topic for another day. We already know how record labels be doing people. Now, just because they put it in the contract that it's a work made for hire, this does not mean that it is actually a work made for hire. Let me repeat that. Just because a record label puts in the contract that it is a work made for hire, this does not mean that it actually is a work made for hire. This is just something that they do. But like I said at the beginning, things are a matter of law, meaning that it doesn't matter what it says in the contract. So this is something that a court would have to determine. A court would have to determine if a song is actually a work made for hire or not. And the court does this by using a test that honestly, they just have to go through on a case-by-case basis. There is no clear way to know if the court is going to say that your song is truly a work made for hire or not. That's something you would just have to go through to find out because the courts are actually divided across the USA on their opinion of whether an artist granting their master rights to a record label qualifies as a true work for hire. Yeah, I know. I wish I could give you more information. Actually, I don't wish I could give you more information because that was a lot of information already. So let me just try to wrap it up and put this in a concise form for you guys. Just know that whenever you register a copyright, please pay close attention to whatever information you're putting down as the author of that song. The author, not the owner. I'm going to stress that again. Please pay attention when you are registering a copyright to whatever information you are putting down for the authorship of the song, not the ownership of the song, because those are 2 different things. And the copyright registration form asks for who is the copyright owner, and it also asks about the authorship. So, two different things. Make sure you're paying close attention to the authorship portion. So, as long as you are the author of the sound recording, or the author of the composition, or an author amongst multiple authors of that, then you can take your rights back from a record label or a publisher 35 years after you signed over those rights to them, as long as you give them proper notice 25 to 38 years after you signed away your rights to them, and hire a lawyer, an attorney to do this, aka me, Ty Law. Yes. Oh, yes. Also, know that this law is under the United States copyright law. So this means that if you do end up getting your rights back, you are only getting your rights back for the United States territory. You will not be getting them back worldwide because this law doesn't apply worldwide. Yeah, I guess that's everything that I can say for that. But let's go back to the Dame Dash Jay-Z Rocafella auction. So now that you're more knowledgeable on this topic, let's go. 2031 will be 35 years after Reasonable Doubt. So Jay-Z, he is saying that whoever wins that auction, they aren't going to make much money off of it because as an author of the songs on that album, he's going to terminate those rights in 2031, which is in 6 years, and he's going to take them back for himself. Vice versa, the city of New York, who is auctioning off Dame Dash's share of Rocafella Records, and Rocafella Records currently owns the master sound recording rights to Reasonable Doubt, they are claiming that even though we're hitting that 35-year mark, it doesn't matter because Jay-Z actually doesn't have the termination rights because Reasonable Doubt was a work made for hire. And it actually says that in the contract between Jay-Z and Rocafella. However, as I just taught you guys, and now you guys are more knowledgeable about this, just because the contract says that it's a work made for hire, it does not mean that it actually is a true work made for hire. This is something that the court decides, not the city of New York. So this is why the city of New York, they had to file a motion, which just means that they are requesting the court to decide whether Reasonable Doubt is a true work for hire, work made for hire, and whether Jay-Z has these rights. And the city of New York's interests are adverse to Jay-Z's. So, of course, the city is going to argue that the songs are a work made for hire. And Jay-Z's lawyers, of course, they're going to argue that no, they don't truly qualify as a work made for hire. They're just going to go back and forth and we're going to see what's going to happen. And I am excited to see how all that is going to play out because I'm just fascinated by all of this because I'm a music business nerd and legal nerd and just a nerd in general. So I'm excited for that. And I know I said that I was going to update you guys on my disappearance, but your girl lives a very busy life. And I'm looking at the clock over there, I'm definitely running out of time. I already ran out of time. I have other things that I need to go do. So I'm going to have to make a separate video for you guys, a separate update video whenever I have the time. And I promise you I'm going to come back and I'm going to keep doing these videos. And I promise you that this update video is going to be juicy because I was not just gone for no reason. I had to take a step back for some serious shit. So we are going to get into that at some point. But I thank you guys for still rocking with me. And I hope you guys are excited because I guess I didn't announce here. I announced on my Instagram. So if you don't follow me on Instagram, go to my Instagram, click the follow because I do post stuff there and I'm going to start posting more things there than I post here. But on my Instagram, I announced that I am now teaching as a professor this semester at the Roc Nation School of Music, Sports, and Entertainment, which is Long Island University's music, sports, and entertainment program. So my class is every single week. It's legal aspects of the music industry. Is 3 hours long, guys. So it's a long class. So because I'm already going to have to prep and do so much teaching there, it's going to be very easy for me to like take little snippets and then come here and make some more content and put more videos out there. So I will be active again starting now. As you see, she is back. Yes, she is back and she is better for sure. I guess that's it for now. I forgot what my outro is because it's been so long. Oh, In the meantime, in between time, do not get lost in the madness that is the music business, because there is a method to the music. Bye, guys.